Where during these webinars, we dive into different areas of law and different practice areas. If you're interested, you can catch our prior recordings of other sessions on the Armenian Bar Association's YouTube channel. And if you want to join the Young Lawyers Committee or the Armenian Bar Association's other committees, or have any future ideas for events or panels, we're always open to suggestions. Please reach out to us at info@armenianbar.org. So before I get into introducing our topic and our amazing panelists today, I want to do a little bit of housekeeping. For any questions, please type them into the chat and we'll get to them, as many of them as we can. And as a reminder, for those of you in California, you can receive 1 hour of CLE credit. Please email info@armenianbar.org after the program's conclusion for the CLE certificate. So without further ado, today we'll be discussing the world of IP law and a day in the life of an IP lawyer. First, a bit about myself. My name is Vati Hindoyan, and I'm the co-chair of the Armenian Bar Association's Young Lawyers Committee. I also serve as Associate General Counsel of the Brands and Marketing Legal Team at Meta, formerly known as Facebook, where I support teams across the globe in the development of marketing initiatives aimed at consumers, generally providing strategic advice on IP matters, advertising, privacy, and other regulatory matters. And before Meta, I was in-house at Disney doing similar things. I'm honored to introduce our panelists today. We have Rafi Zerunian, who's partner and Los Angeles and Costa market leader at Hanson Bridget, Colette Ghazarian, who's associate at Cooley, and Garen Tonoyan, who's an associate at Lowenstein Sandler. So without further ado, wanted to start with each of our panelists. If you guys could tell us a little bit about your career background and specifically about your current position. Rafi, would you mind going first?
Sure. Good afternoon, everyone. I'm Rafi Zerunian. I'm a partner at Hanson Bridget. I've been practicing about 20 years. My practice focuses on trademark and copyright litigation and prosecution. So prosecution involves giving advice on trademarks, trade dress, filing for trademarks in the United States, filing around the world, enforcing trademarks, so sending demand letters, overseeing opposition proceedings in the US and in other jurisdictions as well. There's proceedings before what's called the USPTO's Trademark Trial and Appeal Board. We do that as well. And then about half of my practice is federal court litigation relating to trademark infringement and copyright infringement matters.
Thanks, Rafi. Garen, would you mind telling us a bit about yourself and your career?
Sure. Thank you. So I've been in the IP field for about 10 years, practicing after law school for about 9. I've done litigation and some soft IP before, including copyrights and trademarks and related contract drafting and licensing type of work. But primarily my practice revolves around patent prosecution and appeals work. So for the most part, I draft and prosecute patents in a variety of different technology areas, but primarily in the high-tech sector for semiconductors, software, artificial intelligence, machine learning. That's the focus right now.
Thank you so much. And last but not least, Colette, would you let us know about your background?
Yes. Thank you. I'm Colette Ghazarian. I'm an associate at Cooley. Similar to Rafi, I also do trademark and copyright law. Again, roughly 50% of my practice is trademark and copyright litigation, and the other portion is trademark and copyright prosecution, advising, counseling, managing portfolios, doing some enforcement. I also have some experience assisting on other types of transactions. So in M&A transactions or IPOs, sometimes there's trademark and copyright work that is involved in those transactions, and I've advised on that as well in the past.
Thank you. You guys have such a varied practice. I feel like unlike other areas of law, IP lawyers tend to touch different types of things so often and different spans across industries. You each gave a little bit about like how the different types of things you're doing, trademarks and copyrights, prosecution, litigation. Could you give a little bit more overview on the practice and like the day-to-day essentially of the differences within that space. So Colette, curious on if you could give us more on the trademarks and copyright work that you've been working on.
Sure. I think, like I mentioned, so the day-to-day, there are very different workloads. I think you're right that in my practice, I do touch on a number of different things. So some of what I'm doing, like I touched on, was just the day-to-day counseling on trademark and copyright matters. Clients who want to build up their trademark portfolio, want to maintain their trademark portfolio, they run into an issue and they want to enforce against somebody who might be using one of their trademarks or using their copyright. And that's kind of more, I think, bursts of time, like little chunks of time spent managing multiple clients and kind of, touch points with them. And then there are larger matters, larger disputes, litigation that, you're working much more closely and sort of an everyday workflow.
Got it. How's that in the patent space for you?
Well, in the patent space, my day is split primarily between two main functions, and it's the drafting and arguing, the prosecuting of patent applications involves in-depth conversations with inventors and development or engineering or science groups at our clients, as well as drafting arguments or having telephonic hearings called interviews with the United States Patent and Trademark Office, where we present arguments in favor of our clients in order to persuade the patent office to see things our way. So basically, it's talking to the inventors or the engineers that our clients have and trying to understand in depth the novelty and the unique designs of their inventions or new technology that they've developed, and then formulating according to the legal requirements the documents and the patent descriptions that are necessary for them to get their exclusive rights, as well as then separately interacting with the patent office and arguing with them, whether in written form or verbal form. So that's takes up, the vast majority of my days.
Makes sense. Rafi, I know you've dabbled a little bit in all of the work in the IP space and then also in the trade secret space. Curious if you have anything to add on what Colette and Ganen mentioned or on the other work.
Yeah, so I started my career in patent litigation. So Ganen writes patents. There's another group of folks who litigate patents, meaning they go to federal court or the International Trade Commission and deal with disputes involving patents and patent validity and other issues. I've also been involved with trade secret litigation. Trade secrets patents are filed with the government. Copyrights need to be filed with the government to enforce rights. Trademarks don't need to be, but they usually are. Trade secrets, nothing is filed with the government, but somebody owns a secret like the Coca-Cola formula that derives independent value from the fact that it's secret. So there's been an uptick in trade secret litigation, and it gets pretty technical. So some folks who are good with the science and technology who do patent litigation and are solid litigators then end up in trade secret matters as well, because it's often some sort of technology and understanding, and that's helpful to the litigator in handling the dispute and wrapping their arms around the facts and the arguments and the expert witnesses and all of that. And trade secrets have also a little bit overlaps with labor and employment. Labor and employment lawyers often know about trade secrets and how to attempt to protect them through contracts to the extent they can. It's sometimes hard to do that. And then employee mobility issues, which is when the trade secret disputes often arise. Somebody goes from company A to company B. Company A sues company B saying you took trade secrets and are exploiting them. And so that's often how these trade secret lawsuits arise.
Makes sense. question on this vein of the different areas that impact the patent work, the copyright, trademark, maybe slightly less in the trade secret space, right? There's the litigation, there's the prosecution, transactional work. Each of these require different skills. Curious if you could expand upon like the types of skills, if they're different for each that you find like that are most useful or most needed in these and how they differ. Rafi, if you could start with you, if you have any thoughts on that end.
Sure. So the patent litigation, in my experience, I was at a big firm, high stakes. You know, the teams were from 3 lawyers to 15 lawyers. It did involve a lot of technical expertise. You didn't necessarily have to have a technical background, but it helped. My background was economics and political science, so part of my job was to translate the technological information in a way that people could understand it, because the judges and the judges' clerks were often not technical. And there's just general discovery and research and writing that associates handle. And so it was fun. These cases have big budgets, and it's very, very hard work. The pace is frenetic. You have a team of 3 to 15 on the other side, and there's a lot at stake. So it's just, there's this constant volleying of discovery disputes and just dealing with experts and things like that. So at least in my experience, if you're on a patent litigation case, you're on 1 or 2. That's all you do, because you just don't have time to do anything else. There's that much work that needs to be done. And it's very late nights, it's weekends, it's whatever it takes. It's, you know, this back in the day, traveling somewhere for a few weeks to deal with discovery or document review or client meetings, expert meetings, things like that. I think folks have gotten more comfortable with Zoom meetings, so that probably doesn't have to happen as much. But it's there's a lot on the line, and there's a lot of stress, and it's, you know, it's also from a practical matter, as one develops and has to build their practice, getting these patent cases is more difficult, right? You have to be one of the stars in a very competitive market to get this case that's going to cost $2, $3, $4 million to the client, and may have exposure of 8, 9 figure exposure and injunctions on applying to products that are sold in the hundreds of millions or billions of dollars. So it's there's a lot there. Like, to me, there was always somebody who was willing to work harder. There was an associate I worked with. He would just read a science textbook on the Saturday that he didn't work, because he just wanted to do it. And so I just remember thinking, I don't want it that bad. And I didn't appreciate the science as much. I didn't appreciate the pace. Not to say that the pace of a trademark matter isn't quick, but it was a lot. So I think with trademarks, what you do on a day-to-day basis is wider, it's broader, and potentially not as deep. With patent litigation, you're getting really deep in the science, and you have to learn that science very deeply. For trademarks, it's almost just, you have to know the law, but you don't get as deep unless if it's a particular issue you're dealing with. If you aren't dealing with geographic indications, you don't need to get terribly deep in them. Trademarks are not necessarily industry specific. If you're a highly skilled trademark attorney, it doesn't matter whether it's a nonprofit trademark application or something dealing with technical expertise, because you have to describe, you describe field and function, right? In the most serious of trademark applications, and it has to be something that the consuming public and the trademark office understands. So it's not like when Conan writes a patent and the person at the USPTO who's reading the patent has the expertise that matches up with that, right? So it's different. My job involves negotiating. There's a lot of phone calls, a lot of conversations, there's strategy. frankly, there's relationships with folks you deal with, right? That's pretty important. Maintaining your reputation, having credibility. The good trademark attorneys see each other all the time, so you have to maintain positive relationship with folks, even if the clients have major issues with one another. There's going to be another time where you're dealing with this person again, or the shoes on the other foot. So I appreciate that aspect. There's a lot of day-to-day counseling, just questions. Can we do this? Can we do that? And that's fun. I talk to my clients, I email with my clients all the time. And I love that. I like that I get to see the products that I protect, right? I'm walking to a movie theater, I'm there with my kids and they know, hey, you know, I cleared that title or I cleared the studio name. Or we walk into a grocery store and it's like, I'm the lawyer that protects that, or, it's fun. Like I see my work everywhere and I love that. I, buy my clients' products, I use them. So that's nice. Trademark work often kicks out. So if you represent a big brand, have a big portfolio, you kind of are always getting work, right? And so you develop a relationship with the person who's giving you a work, you develop a relationship with the brand. It's nice. It's nice. It runs deep. And I get a certain amount of personal satisfaction from that. That said, you have to know, you have to know the law. There's a lot of it. You have to constantly stay on top of the law. It's just non-billable work to understand. Like I'm the editor-in-chief of the trademark reporter. I'm basically still on law review, even though I've been practicing 20 years and I'm still not getting paid for it, but I spend 200 hours a year editing this journal to stay on top of the law. I edit a treatise. It's just something you do. It's time away from my family, but it's something I need to do to maintain credibility and to just stay on top of the law, right? It's a lot of work. You have to be, in all of these, you have to be an excellent writer, excellent oral communicator. You have to be right. You have to be responsive. And I think something with trademarks is there are so many matters. You have to be very organized. You have to have an ironclad system where nothing slips through the cracks. And that takes time to build. But there are many tools that folks can use. And then you have to have the ability to switch, right? And then you have to have the ability to, manage your clients. And, once you have a team, manage your team. So I think those are pretty important on the trademark front.
Makes sense. Thank you so much. Some of it sounds similar, like skill-wise, to what I do in-house, juggling different clients, not on the IP front, but switching gears on different topics. But I can definitely relate to that. Gaurav, did you have anything to add? I know you've done patent litigation, but then also now primarily are on the counseling and prosecution side, and obviously the appeals on that end. But if the skills have been different for you as your practices developed or changed.
So in my field, there's a strict governmental technical requirement where in order to be a patent prosecutor, you have to take the patent bar, which requires you to have some kind of scientific or technical degree as a bachelor's or the requisite professional work experience to qualify to even take the test. So that already puts a technical skill set that's required of you. Moreover, in more detail, something that Rafi touched on about his colleague reading a textbook. Plenty of my colleagues have their offices full of a variety of different engineering, science, and scientific and technical literature and textbooks, which is our everyday, depending on the field or the invention that we might be working on. So the skill that's involved there is the ability to translate from a layperson's explanation into the required technical and legal language that would qualify and provide your client the most broad protection that is available to them. And it's different because I think Rafi touched on this as well. As in the patent field, oftentimes the practitioners specialize in different scientific or technical disciplines. And a person specializing in biology might not be familiar with the technical language of electrical engineering, or someone dealing with material science might not be familiar with some kind of aerospace language. So it's very unique in this field that you need to be both familiar with the working terms of the scientific and technical discipline, as well as just like Rafi said, be on top of the law, the ever-changing law, and be able to explain to the clients and the inventors what is required of them, how it works, and how to properly present it so that they get the protection that's as broad and as beneficial as possible, and that's in their favor. So that is combined with having nowadays multinational corporations having engineering and development teams all over the world with a variety of different cultural backgrounds and maybe language abilities. That creates an additional filter or a lens through which this information gets passed through that you are required to translate and put into a format. So there's a lot of people and project management involved as well, because you're essentially operating as an extension of a corporation's development or production or engineering team at the last step of the chain, where a product or a process is developed, and your goal is to protect it before it goes into production, implementation, or on the market. So you should be able to juggle and interface with a lot of different types of people from a lot of different corners of the world, on top of these technical and legal requirements. So it's definitely very interesting, and despite how maybe technical or boring it might be to some people, it's rarely a boring day, and there's always something new to learn.
Makes sense. The only patent experience I ever had was a door patent, so I won't call that interesting or exciting, but I can only imagine some of the work that you're looking at on a day-to-day basis. Also, one thing that resonated, what Rafi said earlier, was in the trademark space, where like you're a repeat player with some of the legal world, right? Like it's a small space. I wonder if Colette or anybody else has anything to add on here. Like I remember when I switched from litigation to transactional, I feel like it changed my worldview of like how to behave with counsel and like what your priorities are, and just the general nature of the engagement. Even an adversarial one is not so adversarial at the end of the day. So curious if you see that, like when in your practices, what if you are actually switching your hats from a day-to-day basis or like hour-to-hour basis, what difficulties or benefits have you seen on the skills on that end?
No, definitely. I think, I'm sorry, can you repeat, I wasn't understanding how you framed it, like what the question was.
On the other skills similar to that, like will you do litigation and then some counseling and some just transactional work, like the skills differing on that end? Have you seen a difference there when you're switching hats?
Yeah, definitely. I mean, I think when you're doing, there's always sort of like a underlying kind of keeping in mind that like you're dealing with a business usually, and there's always going to be business considerations. And I think sort of thinking about how framing a strategy around understanding where the business is at, what the business's priorities are. And I think sometimes that can change in litigation if you're the one enforcing it. They might have different priorities. The stage of the business matters, I think, a lot. So I think that's another skill set that's really important when you're entering in this space. Being able to switch your hat in terms of, oh, I'm dealing with a smaller company, or maybe a company where IP might not be very important, or a company in an industry where IP is very important. So I think that's one skill. I think another thing to add, I know everybody kind of touched on this idea of staying up to date on the law, and I think I'll say from a copyright perspective as well, that's definitely important. And I think staying on top of new technologies is also very important, particularly in the copyright space. Right now, you know, with AI, like keeping track of how that technology is developing, because that will directly influence the legal landscape around copyright. Having some understanding there's some technical knowledge that comes into play in copyright as well. For instance, if anybody's been tracking the Marvin Gaye, Ed Sheeran music cases, those actually got pretty involved in sort of musicology and comparing notes. So it's like there is a little bit, and that can be fun. It's like sort of having a high level, like just enough of an understanding of the material that you're dealing with to be able to then make a compelling legal argument.
So now, switching gears a little bit and going back in time a little bit, how did each of you get started in IP, and how has your practice developed over that period? Rafi, if you don't mind going first.
Sure, happy to. So I went to Berkeley for law school, and they have a very good intellectual property program. I've already went to Berkeley too, a few years after me. They have really good professors, basically a law review you can join, institutes. They have really compelling speakers that come. So it just made it really easy, and there were many opportunities to get into the IP space. So I graduated in 2003. So back then there weren't as many trademark jobs as there are now. This is there was the .com bust and boom, but the last 15 years of startups that started with nothing and are now, there was no Facebook, there was no Instagram, Google was practically nothing, Amazon was nothing. All of these employers, right, they have teams of trademark lawyers. So there just wasn't as much trademark work. They were really hard positions to get. Somebody had to leave to get one. So I ended up going to a firm, I was a summer associate there, and then I clerked for a federal judge for a year, and then I went to this firm, and we focused on just big patent and antitrust cases. There were trademark lawyers there. It wasn't a position I can get in this. Back then, you couldn't move from one department to the other. So I did that for 2 years. I realized that I wasn't going to be happy making a living with the patent litigation. Part of that is I knew that I just couldn't compete with these folks. It wasn't to the best of my skills and my skill sets. You think about it like doctors, you have your dermatologists, you have your emergency room doctors, you have radiologists. These are different skill sets. Law has different skill sets, including in the IP field. Like the last thing I'd want to do is sit there and write patents all day. Like that sounds really, really hard. What I do is hard too, but it gets a little bit easier, right? I'm persuading an infringer to stop using a mark. I'm persuading, this morning I'm talking to the examining attorney at the USPTO trying to explain a situation about getting my client's trademark application through. And I'm good at what I do, right? And so I'm a better trademark lawyer than I would be a patent litigator, kind of given my kind of natural skills. So I went from a big firm to a small firm after 2 years, and it ended up being a good move in terms of my practice. This firm had major clients. It was mostly litigation and enforcement. So I learned that very well. I cut my teeth on protecting some famous trademarks. There was a certain amount of trademark prosecution as well. Some international prosecution as well. So typically trademark lawyers are broken up between, not all the time, but they're the people that, especially in big firm departments, that you'll have the folks that clear trademarks, advise, file trademarks, deal with the office action responses, and then they oversee international trademark prosecution, which is you have the lawyers all over the world. We call them local counsel. Some people call them foreign associates. They're the ones that file trademarks on our clients' behalves in these other countries. And then there's the people that litigate, and the people that litigate aren't necessarily a full-time trademark litigators. Like that's hard to find a firm where there's so much trademark litigation that you're only staffed on trademark cases. It's often you're working on a copyright case, maybe a trade secret case, and it's hard to fill your plate. There's a few firms like Colette's and mine where there's a lot of it, but those are really hard jobs to get, and you can't bank on them. So over time, and as I grew my own practice, we were in San Francisco, my wife and we ended up coming to LA. I founded Hanson Bridges office 9 years ago. And over time, my client base has grown. And I used to do more litigation than I do now. It used to be closer to 75%. And now it's about 50 litigation. And then I oversee a team, right? I manage a team. I have 3 associates that work for me full-time, 2 paralegals, a docket clerk, a secretary. So we work together cohesively as a team. And if, cases get heavy, I have other partners that come in and help. And if there's document review, we bring in other associates as well to help. So over time, I've spent, a lot of the last 10 years really doing sophisticated trademark clearance, trademark filing strategies for major brands. We routinely are doing 50 to 90 country clearance searches, and we'll do bespoke trademark application strategies and these beautiful charts, color coded and things like that. I have a wonderful team that does a lot of the hard work there. But so you do that, and then I'm still, overseeing a lawsuit and handling that. So it's, that's where it is now. It's just, been doing it for 20 years, and I'm not sure exactly what the practice will look like in the next 10. I didn't think my practice would look exactly the way it did 10 years ago as it does now. Very happy with where it is.
Awesome. Before I go on to the other panelists, just want to say thank you for submitting questions. I see them keep adding more questions. We'll get to them at the end in the Q&A, I promise. Now switching back to the question of like how you started in IP and how has your practice changed, Gaurav, wanted to toss it over to you to hear about your journey.
Sure, thanks. So I started off with a bachelor's degree in physics, knowing that I was interested in law school, and I found out that with a science background and a technical degree and a legal degree, the patent field is where you're supposed to go. And around that time, things were just getting interesting and hot with the Apple and Samsung litigations about the iPhone and the phone designs. So it was a popular topic in the news and so on. So while I was in law school, I interned at the USPTO 1 year. And then I worked at a small boutique IP firm for a while that did primarily litigation and soft IP. And then after that, I worked at a couple of more boutique IP firms where I focused on patent drafting, prosecution, more limited roles in the litigation side, but also did some contract drafting and negotiation for private equity firms that were looking into acquiring startups in different fields, and did some licensing work as well for, again, mainly for patents, but for a variety of different intellectual property types. So I bounced around from some smaller firms, boutique firms, worked at a regional IP boutique based in the Philadelphia area, making my way to my current firm right now, Lowenstein Sandler, where, as I mentioned before, I do primarily patent prosecution, but that also over time began involving more and more work related to guiding the teams that our clients have in terms of long-term intellectual property strategy. So developing their IP portfolio. So Rafi touched on the trademark and the copyright side. This involves identifying what the business goals of your clients are from the perspective of technological development, and manufacturing a long-term strategy for them to be able to capture certain sections in the market, depending on what their strengths are, depending on how their development teams work, and what their ultimate goals and resources are. And that becomes more of a global strategic type thinking, as opposed to more technical and legal minutia type thinking. So over time, my practice has progressed into that direction, where the mix of clients from small mom and pop startup size businesses to multinational, Fortune 100 businesses, have an entire spectrum of different needs and different strategies on different time frames that you would have to adapt and create for them. So it's been interesting in that regard. And as Colette mentioned, the new technologies that are coming up, it doesn't just affect the law and the impact on our clients, but it also affects the way that we work. And I think we might get a chance to talk about that as well.
And Colette, will you tell us a bit about your journey into IP law?
Yeah, so my journey into IP law, I think, started before law school. When I was in college, I thought I wanted to get into entertainment, get into the music industry. And as I kind of explored that option, that was also sort of there was a lot coming to head with technology and IP, and I was fascinated by the way that these new technologies were affecting copyright issues and other IP issues, and that was really what interested me and then spurred me to going to law school. So I went to law school very focused on doing sort of copyright and to a lesser extent trademark work. I went to Harvard for law school, and sort of as a 1L, because I knew this is what I wanted to do, I kind of sought out the opportunities that would allow me to learn about IP, and then specifically dive into the intersection of technology and IP. And Harvard was great in that it offered sort of specific seminars on that topic. There was like the cyber law clinic that handled sort of, as the name suggests, cyber law, and I participated in that. One of my summers, I interned at the Electronic Frontier Foundation, which is they focus on like digital civil rights, and I was doing specifically IP work there. And then, when it came time for OCI, I was interviewing at firms, looking specifically at firms that had sort of a soft IP litigation practice. I also knew I wanted to be in LA, and given sort of my interest in the tech side of things, my experience kind of interviewing at a lot of these firms was that the bigger firms in LA that did maybe like copyright litigation tended to be more on the content side of things, and I was very interested in being on the tech side of things. And Cooley has a reputation as a tech-focused law firm, and so that's sort of how I ended up at Cooley doing what I do. Now my practice, I do a good amount of copyright. I think there's probably more trademark work that I do now, and I think that's more the result of the fact that there's more trademark work being done, or like our clients have more trademark issues come up, and so that's sort of the practice area that I work more in. In terms of sort of how my practice has maybe developed over time, I think initially I'm the most junior one on this panel. I'm a 5th year associate, so like a mid-level. As a junior associate, I was getting a lot of early sort of client contact opportunities, but it was sort of heavily supervised by a partner or a senior associate. And as I've gotten more senior, I'm sort of the point of contact for clients on particularly the prosecution and advising counseling matters. I'm running the calls with them, coming up with a strategy. I might get some partner input to the extent it's a more involved issue. And then on litigation matters, those tend to be more heavily staffed or like with bigger teams. But I'm reaching this point where I'm no longer just, stuck doing doc review. I'm kind of able to run meet and confer calls, doing a lot of the drafting of briefs. And so that's sort of how that's been my career trajectory so far.
Thank you all for sharing. And that's funny. I think for many people, and most of you here, law school actually had quite a determining factor, like what was available and like thrust at you, which is just like exposing you to certain areas. So for those that are law students that are watching, choose wisely. So wanted to switch gears a little bit, given that we are the Armenian Bar Association. I want to talk about what it's been like being an Armenian in your field, and kind of piggybacking off of that too, if you found a way, both how it's been like your practice being, and if you've been the only one of few, and also if you've been able to figure out a way to make like an impact on Armenia or fellow Armenians with your career. So I know it's two questions in one, but opening it up to the floor, I don't know if anyone wants to take this first, particularly.
I think Karan does.
Oh, you're on mute, got it.
Thanks, Rafi. I'll definitely give it a shot. It's definitely true that Armenians in IP, or at least in patents, are few and far between, and it's rare that I'm not the only one in a firm or in a department that's Armenian. But there are more than I expected, which is great. It just means that I guess more of us find it a interesting and engaging field to do work in. And big shout out to the Armenian Bar Association, this being an Armenian Bar Association event after all. I've had the honor and the privilege to dedicate some time to doing IP related work with the Armenian Bar as part of the Armenian Bar Association's Intellectual Property and Information Technology Law Committee, which was formed in 2018 and really started working in earnest in 2019 with my co-chair, Denise Darmanyan, also from the East Coast in New York, also an IP and attorney, to analyze, to do a variety of different events, but primarily our focus was to analyze the state of IP law and regulation in Armenia, given the fact that there's a lot of technological and scientific development happening there, a lot of companies moving there or opening offices, a lot of new software or tech innovation taking place. But it was noticeable that the legal, statutory, and regulatory environment and framework was not keeping pace with the business and the technological side of things. So based on the requests or the problems noticed by the private sector, I mean the businesses, the academia, as well as government institutions and colleagues in the public sector, we've identified a series of issue areas within the IP or startup ecosystem fields that had room for improvement. And initially, the initial phase of our work as the first part of our project during 2019, 2020, primarily during 2019, we got together with a group of IT professionals from the US, from other countries, from Europe, from Russia, as well as from Armenia, of course. And after doing an analysis of these primary issue areas, presented a proposal of recommendations, a report that proposed a set of recommendations to improve Armenia's IP regulatory and statutory framework that would facilitate businesses, academics, and others to generate and protect their IP in Armenia. So as part of that proposal, there were sections related to patents, to some trademark issues, but also to some corporate law issues that affected startups, such as protection of minority investors and other corporate law related issues. As part of that, this was presented to um, in a summit format to government representatives, and eventually developed into a package of legislative proposals that I am happy to announce, despite COVID, despite the war, and despite many delays, eventually something like 80% of our recommendations have made it into law, enacted into law in Armenia, including some language that makes Armenia one of, if not the only country that exclusively says that software can be patented as such. It's a small little win, but is able to put Armenia on the map, at least for people interested in that field. But we're continuing working in the same direction with a set of IP professionals, again, primarily from the US and Armenia, but oftentimes around the world, on now focusing on the implementation and enforcement of the IP, because you can have the best laws or the best written regulations, but unless they're being properly utilized and enforced and implemented, especially by the judiciary, but by the private sector as well, it's not very effective, and it's not worth much if it's just the words on paper. We're always looking for additional help, additional input, advice, always looking for opportunities to learn more and collaborate with our colleagues in Armenia and the US, and as I said, around the world. So that's my little plug for the IPIT committee. If anybody has any questions, anybody has any time that they would wish to volunteer, or maybe their firm has an opportunity to bring on the Armenian Bar Association as a pro bono client, as I have, and has some allotment of pro bono time that they could dedicate, would be very happy to talk to you, to work with you in that regard.
That's
Thanks.
amazing. I wouldn't call it a small win. That's really incredible work that you and the team have been doing. Wanted to ask Colette or Rafi if you had anything you wanted to add about like being Armenian in the field, and then afterwards we can get to Q&A in the last 5 minutes. All right, we can get to Q&A then. I'll take this. I know we've been chatting a lot. Thank you for the questions that came in. I'm gonna try to go through these in the order that they did come in. Bear with me, the first one's a little longer. So this is directed to Godin actually, about as an attorney with an engineering background, this person's interested in pivoting their practice and taking the patent bar, and is asking if you would recommend that to someone who's a lawyer and wants to make a switch mid-career. And would that be limited to prosecuting, and would that person be limited to prosecuting only electrical computer patents given their background is computer engineering, or would they be able to prosecute like mechanical apparatuses as well, software or other areas?
So I can touch on most of those aspects of that question. You're definitely in a great position to pivot towards patent prosecution. Depending on how far along in the career you are, and where you are geographically, and what your goals are, it's definitely possible, and you might like it better than what you're doing now. I don't know what you're doing now. But there's plenty of, our practice groups tend to be, I guess, on the older side, because many people switch careers, many people take additional degrees, a variety, actually a majority sometimes of practitioners have advanced degrees in a scientific or technical discipline. And this helps because oftentimes you are speaking with people with master's or PhD level degrees in scientific disciplines, and you have to be able to talk on their level, so to speak. With regard to whether or not it would limit you to a specific field, technological field for your practice. So as I mentioned earlier, I have a bachelor's in physics. Although that kind of gives me general understanding of a broad spectrum of things, as ultimately, whether you're in electronics, whether you're in material science, or even biotech and so on, somehow, somewhere, everything boils down to the basics, and that's physics. However, for example, some nuanced or advanced concepts in these technical disciplines, let's say for biochemistry or other chemical related technical areas, become a little bit more difficult because I don't have the sufficient background knowledge and nuanced knowledge in order to reasonably and effectively, first of all, understand the technology or the science, and secondly, to argue about it. So you are not limited or so despite being a physics background, the primary stuff that I work on is, as I said, in like electrical engineering disciplines, like semiconductors, and software, like artificial intelligence, machine learning, distributed computing, and things like that. And these are things that, I mean, I did have a limited computer background in my past, technically working in just of my own self-study. But a lot of it is something that was learned over the years on the job or through interactions with clients and scientists and engineers. So you are not limited, and your career can pivot over time in a specific direction. But it may be, you know, a steep learning curve. But it from my experience, people who are interested in science and technology and already scientifically and technically inclined, I don't know if I'm allowed to say nerds, uh, um, and you know, have that intellectual curiosity, will find it easier than those who are not technically inclined or have that innate curiosity. So as a person asking, I think already there's an indication that you might be that type of person. So it might be easier for you than for others. I hope I was able to kind of comprehensively answer that.
Thank you. And I think actually the next question is mostly to you too, Gordon, which is can a patent prosecuting attorney also handle other transactional law, or do they end up getting very specialized and doing not much other than patent drafting prosecution?
That depends more on the firm and the practice group. So in my experience, as I mentioned, I've worked on the transactional and the litigation side. I've worked on licensing patents or focusing patents to coincide with standards that are being developed in one industry or another. Um, that that allowed me to have a little bit of a broader scope of practice. I know patent prosecutors who, for most, if not all of their career, all they did was just draft and prosecute patents. So it's more of a function of where you end up, meaning, like I said, the type of the firm, geographically, maybe the size of the firm or the department, and also the flexibility. So some firms have more interaction across departmental kind of teamwork, and some do less. Sometimes you're more siloed in some places than others. But it also depends on your proactivity and ability to interact and find common ground with different partners at your firm, or why not maybe have connections outside of work, perhaps through the Armenian Bar Association, that you're able to bring in different scope of work and focus on that as well, and allow yourself the opportunity to branch out and kind of explore different areas yourself.
Thank you so much. And that's all the time we have. We're exactly at time. Thank you to our incredible panelists for all your wise words of wisdom, and just hearing about your paths in this space and all the work you do is very inspiring. For me, I'm sure for everybody else listening. So thank you all, and tune into the next webinar we'll have, I'm sure, very soon. Thanks, everyone.
Thank you.